Next, we have Jordan Diamond, also with the Environmental Law Institute.
Okay. Hi, as Lisa mentioned, I'm Jordan Diamond from the Environmental Law Institute, and as Teresa promised, is that better? Try that. But as Teresa promised, I'm going to delve a little bit more into the RESTORE Act. And before I do that, I want to point out the binders that you have in front of you. If you don't have one in front of you, feel free. There are some extras on the tables around. There's some at the front of the room. We encourage you to take a copy for yourself. If you're looking for a present to give to someone else, take one for your best friend. But we really do, this summarizes most of the information that we are going over today. Okay. It summarizes most of the information that we're going over today. It includes some additional detail. So we do encourage you to take these. And our contact information is on the back. We, as Teresa mentioned, we don't lobby, we don't litigate. At the Environmental Law Institute, we really focus on how can we kind of educate and get information out there. So we want to be a resource, so please don't hesitate to reach out anytime. If you do open up, you'll see the 4 tabs. We have our overview materials that summarize a bit of what Teresa mentioned during her presentation. We have a section on the natural resource damage assessment, and then, relevant to what I will be talking about, we have our section on the Clean Water Act. So what I'm about to go over is summarized in a different manner in these pages, and I'll refer to a couple places in here as I'm going through. So the RESTORE Act. As Teresa mentioned, why are we even here talking about the RESTORE? Why was it needed? The idea was the Clean Water Act punishes you if you discharge oil against its prohibitions on discharging oil. But those funds usually go into the Oil Spill Liability Trust Fund, not to whatever region or area or entities were affected by said discharge. So the RESTORE Act was an effort to change that, was an effort to take those penalties and direct them back to the people, the regions, the resources that were harmed. So, and as Teresa mentioned, it would be 80% of it. Now, I just want to emphasize that RESTORE does not do this permanently. The next spill that occurs, those civil and administrative penalties, and just a clarification point that any criminal penalties that come from the Clean Water Act won't go into RESTORE. It only applies to civil and administrative penalties. The criminal penalties will go back, they will follow their standard process. But I just wanted to emphasize that this is only to RESTORE, and this is in part because there was a huge public push to get this passed. It took a lot of effort and a long time. Brief history of the RESTORE Act coming to being. So the U.S. Department of Justice, who's responsible for filing for these penalties, they filed suit against the responsible parties December 15th, 2010, so going on 2 years ago. In the summer of last year, in July for the Senate and then October for the House, the RESTORE Act was first introduced. They were not the same version of the bill. The bill actually varied between those, but it was before Congress and being discussed. And then this past summer, a year later, we actually got our first consent decree. MOEX 2007 LLC, one of the responsible parties, actually settled their claims with the U.S. government, and it included $45,000 for Clean Water Act penalties. My apologies. And then we went, and following that, we got the actual passage of the RESTORE. Now, you didn't hear about the passage of the RESTORE, you heard about the passage of the Transportation Act. The RESTORE was actually added as an amendment to the Transportation Act, and when that was pushed through, RESTORE Act was then implemented. In largely, there were some definite differences and went through conference committee, but in largely the way that it had been presented to the Senate. So what will the Act do? Teresa referred to the 5 different pots that are created by the RESTORE Act. So the RESTORE Act takes the 80% of the Clean Water Act civil and administrative penalties, and it funnels them into a restoration trust fund. That restoration trust fund will be overseen by the U.S. Treasury Department, the Secretary of the Treasury. And that's our first timeline. There are actually very few timelines included in the RESTORE Act. There are a lot of requirements, there are a lot of processes, there are very few concrete timelines. One of them is that the Secretary of the Treasury has 180 days from the date of enactment, so from July 6, 2012, to publish rules to regulate basically how the trust fund is administered. And so those are rumored to be in progress and hopefully coming out soon, because within that 6 months, those rules have to be subject to notice and comment. So there will be an opportunity to comment on those rules. So if they're bumping up against an early January deadline, theoretically we will see those relatively soon and be able to comment on them. And I just want to emphasize one other thing before actually delving into the pots, and Teresa was talking about this. The trust fund is designed, and specifically the purpose of it, is to help the Gulf recover economically and environmentally from the Deepwater Horizon disaster and from anything else. So it is about restoration and recovery, but it is not limited to the impacts of the oil spill, and that obviously gets back to the questions that were being asked about the interaction between NRDA and Restore, and the concern of if you begin to restoring things with Restore funds, then does that prevent you from getting compensation for those same injuries under the NRDA process? It is a big question. I don't think there's any clear answer about the best way to go forward and ensure that you're kind of maximizing the value of what you get. But it's just something that's important to keep in mind. So I'm going to go through each one of the pots of money. We don't know how much will be in each pot, but we know what proportion will be in each one. So I'm going to go through them one by one. And I will take a few kind of clarifying questions at the end, but please raise your hand at any point. There's a lot of text on these slides, and I'm happy to dig into any of them. So first, we're going to begin with equal share state allocations. 35% of whatever the final amount that goes into the Restoration Trust Fund, 35% of that will go directly to the 5 Gulf states in equal shares. So, great at math, that 7% of the fund will go directly to each individual state. Now, for 3 of the states, for Texas, Alabama, and Mississippi, those funds go directly to the state just in a lump sum. The statute lays out, however, how the funds are divvied up in Louisiana and Florida. And David will go into this in more depth when he talks about Florida. But I'll just note that in Louisiana, 70% of those funds, so 70% of the 7% of an unknown number, go straight to the state of Louisiana. 30% go to coastal parishes affected by this bill based on a set formula. It's a weighted average of distance from this bill, proportion of miles of shoreline oiled, etc. In Florida, it's a little bit different. 75% of the funds go to what are stated what are going to be disproportionately affected counties. There's 8 counties by state law. Florida statute, it specifies which of those counties they are, and they will get 75% of the funds. The other 25% goes to non-disproportionately affected counties based on a weighted average formula. So again, these funds go directly to those entities. So a few basics about these funds and what they can or can't or should or maybe will be used for. So as I mentioned, the lead entities, and I'll just notice we have, for each of these pots, I've got the same categories. In this first box, the lead entity, the 2 that are in italics, the Mississippi Department of Environmental Quality and the Florida, the reason those are in italics is because those are the only ones that change across the pots. For the other pots, the Alabama Gulf Coast Recovery Council is the designated state entity for each of the pots. Same with Texas and Louisiana. But Mississippi and Florida, it changes. So in Florida, funds go, as I mentioned, directly to the affected counties. Now, what are these funds used for? What are the allowable uses? Well, first, in order to get the funds, all states or localities and local governments that receive funds must develop a multi-year implementation plan for what's going to happen with those funds. And they must certify that the plans are designed to restore and protect Gulf resources and carry out one or more of the allowable uses. Now, what are the allowable uses? They are very clearly specified. They are somewhat clearly specified. They are laid out in bullet in the statute, and I recommend you can actually go and we list this precise wording in here. It's good to refer to them because you have to meet one of those bullets. On the other hand, those bullets are fairly general. The difference between restoration and protection of natural resources, a lot can fall under that category. And then you get down to something like workforce development and job creation, flood protection and infrastructure, infrastructure projects benefiting the economy. It covers a wide spectrum of uses. So the question of how these funds will actually play out and what types of projects they will actually support is a significant one. Okay, so going back, so those are the allowable uses. They also have to certify, the state or local government has to certify that they were selected based on meaningful and broad-based public input, that they're based on the best available science, and that they were selected consistent with whatever the state procurement rules are for comparable projects. Okay. Let's get through that. Now, what does meaningful and broad-based public input actually mean? That's the only guidance that we have from the statute. There is some meat, meaningful, you can argue, that should be relatively robust. Broad-based, that should, provide an opportunity for the public at large to be involved. But it doesn't give much guidance on what that will actually look like in practice. That may vary from state to state dramatically. And there's also a note that states may use any appropriate procedure for public input, including existing task forces or other bodies. So that's one thing just to kind of keep an eye out for, is that their method for engaging the public and for involving people, or if you're setting up this process, the process you may set up may take advantage of existing bodies within the state. Another box that I have carved out here is local hire provisions, because this idea of a restoration economy has been a very important one and garnered a lot of attention. There is, throughout some parts of the Act, there are mentions. There's nothing all too specific about it. But within this pot, they do mention that states and localities must certify project selections were consistent with state rules, and they may give preference to individuals or companies either located in, headquartered in, or principally engaged in business within the given state. So this may actually be interesting in other parts of the Gulf that have local hire laws. For example, Mississippi and their Jobs First legislation that actually creates a state policy for local hires. Now, the idea that it can be someone that's either located in or principally engaged in still leaves that fairly broad, but it's an interesting thing to keep an eye out for. And as I mentioned, there are not a lot of timelines in the statute. There is no specific timeline for when the states and localities have to develop their multi-year implementation plan. Part of this makes sense because we don't know when the funds will come about, and it's hard to create a very detailed plan if you don't know how much money you're allocating. On the other hand, it does leave some discretion there. So that's the first pot, the equal share state allocations. The second pot is the Gulf Coast Ecosystem Restoration Council. And I'll make one note that I'm doing these by size. I'm also doing these by how they're mentioned in the statute. So if you ever feel like you want a bedtime story, you want to actually read the Restore Act, this is the same order that you'll see them displayed there. So the Gulf Coast Ecosystem Restoration Council that Teresa has mentioned. 30% of the fund plus 50% of any interest earned from it. That's why it goes second. It beats out the third pot by that 50% interest. The lead entity obviously is the Gulf Coast Ecosystem Restoration Council. 11 federal representatives, a representative from each of the 5 state governors. And there will be a federal chair selected by the state participants, only by the state participants. That has not occurred yet. There's been lots of speculation about who the lead will be, but that has not occurred yet. One note about the council, just to emphasize something Teresa mentioned, is that the Restore Council now aligns pretty closely with the NRDA trustees. As she mentioned, in the executive order that Obama recently issued that actually calls for the disbanding of the existing task force, he appointed the Environmental Protection Agency and the U.S. Department of Agriculture to the NRDA Trustee Council, which is within his powers. So those now line up. The federal representatives on the 2 bodies are the same. So that has, as she mentioned, has people thinking about what sort of coordination may be foreseen between those. So what is the council actually going to do? The council has to develop a science-based comprehensive plan to restore and protect natural resources. It has to prioritize projects that contribute to Gulf restoration regardless of where they are, in what state. And as has been discussed, they must include, and the exact words are, fully incorporate the findings of the task force. And finally, they must include a 10-year funding plan, which has to be updated every 5 years, and a 3-year list of projects updated annually. So what can go into this comprehensive plan? What types of projects? It can only include projects to restore and protect natural resources. This is the key difference between the council's pot of money and the equal state share allocations. It is not used, or is not on its face appear that it allows use for economic restoration or recovery. So the idea is that the projects must, they'll be prioritized according to the extent that they contribute to natural resource protection and restoration, large-scale projects and programs that will substantially contribute to restoration and protection of natural resources, and projects contained in existing Gulf Coast state comprehensive plans, again, for natural resource restoration and protection. And finally, restoration of the long-term resiliency of natural resources. So the common factor there is the natural resources, restoration and protection of natural resources. In terms of public participation opportunities, again, these actually get a little more vague. The appropriate, which is not defined in the statute, but appropriate council actions and deliberations must be made available to the public via electronic means prior to any council vote. I personally do not know what that means. The hope is that this will provide an opportunity for the public to engage. And if the task force is any indication, the task force, as Teresa mentioned, held over 40 public stakeholder meetings. They were very actively reaching out to people and gathering public input. It remains to be seen what approach this council takes to incorporating public input. And then the second kind of formal opportunity is that the comprehensive plan has to be subject to formal notice and comment before it's finalized. So when will this occur? The council has 180 days or 6 months, so again from July 6th, which takes us to early January, to produce a proposed comprehensive plan. That's the plan that will then be subject to notice and comment, and then it has to be finalized within 1 year. These are, again, there's only 4 deadlines. I'm sure I'm gonna regret saying that. I believe there are only 4 deadlines included in the RESTORE Act, and these are 2 of them. And then in terms of local hire provisions, this is the one other place where there is specific mention. The council is actually required to develop standard contract terms for any projects implemented under the comprehensive plan that give preference to individuals or companies located in or principally engaged in business in one of the Gulf Coast states. Jennifer.
Is the 1 year from the same July 6th date, or is it from the end of the 6-month?
It's from the July 6th. So they have 6 months for the initial plan and then basically another 6 months to finalize it. And I keep specifically saying July 6th because that's the date of enactment. RESTORE was actually passed in late June, on June 29th. That's when it passed the House. But this clock actually started ticking once the president signed it into law, which occurred on July 6th. So as I mentioned, there are local hire provisions. So that is the council's pot of money. The third is impact-based state allocations. So the first pot, equal shares to the states. The second, the regional council. And then third, we have 30% of the fund that will be given to the 5 Gulf states based on what impacts they suffered as a result of Deepwater Horizon. How this will be calculated, whatever the total amount is, it will be calculated using a weighted average based on the proportion of shoreline oiled, the coastal population in the various counties based on the 2010 census, and then the distance from the oil rig. And that's actually, it's a combination of the nearest and farthest point, and you use that as the average. So that's how the funds will actually be allocated between the states. This pot of money, as mentioned before, Alabama, Texas, Louisiana, those entities will be the same ones handling the equal share allocations, will be the same ones handling the impact-based allocations. In Mississippi, it's a little bit different. In Florida, it's very different. In Florida, there's a consortium of local political subdivisions. This is called for in the statute. It requires a minimum of 1 representative from each affected county. And that consortium there is a consortium being formed by the Florida Association of Counties, and David will give more detail on that in a moment. So what do the states have to do to get funding under this bucket? All states receiving funds must submit plans for their expenditures. Now, the first pot of money, the equal shares, the other state pot, they have to certify that their plans meet certain requirements. These plans actually have to be approved by the council, and they must be consistent with the council's comprehensive plan, and then again, to be approved. Now, one footnote that often catches folks is that the approved by the council does not actually follow the council's normal voting procedures. To be approved, it just has to be basically certified by one state member and then affirmatively voted upon by the chair, which is different than the council's other voting. So what goes into these plans? What's allowable here? What's allowable here is pretty much the same thing that's allowable in the first pot. So although it has to be consistent with the council's comprehensive plan, the allowable uses list is specifically the same set of allowable uses as the other state funds. One of the differences is that there's a limitation on infrastructure funding. Only 25% of the funds can be used on infrastructure unless a certain set of criteria are met. But in terms of kind of purpose, the projects, programs, and activities must contribute to the overall economic and ecological recovery of the Gulf Coast. And then again, just to emphasize that they have to take into consideration and be consistent with the comprehensive plan. In terms of participation opportunities for this pot of money, there aren't any specific participation opportunities mentioned. Local hire provisions, there aren't any specified. And then timelines, again, there isn't anything specific other than the fact that whenever the states come up with these plans, once they submit them to the council has 60 days to review and issue a decision on them. If they don't, then the state can seek judicial review. Those are the three main pots of money. That accounts for 95% of Restore funds. The remaining 5% is split between two smaller pots, each getting 2.5% and then 25% of any interest earned on the fund. And those are the Centers of Excellence and the Restoration Science Program. The first one, the Centers of Excellence. Again, I've highlighted the lead entities. In Florida, it's a consortium of public and private research institutions, including the Florida Department of Environmental Protection and the Florida Fish and Wildlife Conservation Commission. What will these funds be used for? They will be used to support one center of excellence in each of the Gulf states, 5 centers of excellence, period, that should be devoted to Gulf Coast science, monitoring, and technology. And each state is required to provide information to the council annually. The council has to include that in their annual reports to Congress. So what are the centers of excellence supposed to focus on other than science, monitoring, and technology? The idea is that this is set up as a grant program, and the states will grant funds to applicants with the broadest expertise in one of the following 5 areas of specialization: coastal and deltaic sustainability, restoration, and protection; offshore energy development, including improving sustainable and safe development; coastal fisheries and wildlife; and sustainable and resilient growth and economic and commercial development; and finally, comprehensive monitoring and mapping. It does not have to cover all of these. Each center can focus on just one, or they can focus on multiple. The final 2.5% plus 25% of the interest goes to a restoration science program. The Regional Science Observation Monitoring and Technology Program, RSOMT, if anyone comes up with a catchy way to pronounce that, I'm all ears, which will support research, observation, and monitoring to ensure long-term sustainable of Gulf fisheries. Now, this will be led by the NOAA administrator. In various parts, they are required to consult with the director of the Fish and Wildlife Service, the Gulf Fishery Management Council, and the Gulf States Marine Fisheries Commission for different parts of it, and they can actually allocate funding to the State Marine Fisheries Commission. The idea is that they will fund long-term, non-duplicative projects that address data collection and monitoring needs regarding Gulf fisheries. Now, interestingly, it also restricts what these funds can be used for. So funds may support marine and estuarine research, ecosystem monitoring, and ocean observation, data collection and stock assessments, pilot data collection programs, cooperative research, and then up to 3% can be used for administrative expenses. Funds explicitly may not support existing or planned NOAA research unless the specific grant recipient agrees to that. Implementing or initiating regulations, NOAA cannot use these funds to initiate any new regulations, or developing or approving limited access privilege programs in Atlantic fisheries. To my knowledge, is the only part of the statute where there are specific no's. And those are the 5 key pots of money. That's a fair amount of information, and I glossed over a lot. I just want to emphasize that in order to cram that in, there are a lot of generalities, so I'm happy to take a few questions with, again, the caveat that if they're Florida-specific questions, you're about to get a whole special presentation on that.
Good morning, Jordan. Don McCormick with the Regional Planning Council, representative of the NEP. As you were discussing the impact-based state allocations, I got the impression that we don't have to go down to the seashore and pick up a globule of mud and oil to prove the impact. There are other criteria for the impact besides goo on the beach, I take it.
There are, so it's a weighted average. The idea is that the amount of impacted shoreline is one of those factors. You did say impact-based allocations, is that correct? You said the impact-based pot? Yes, yeah. So it is a weighted average, so the idea is that you will get a higher overall average depending on what distance of your shoreline has been oiled or impacted, but it's, that could be one category where it goes to 0.
Ralph Brooks again. I had if I could, 3 quick questions. On the impact one, you said overall economic and ecological recovery of the Gulf states. Is that each project must have both economic and ecological, or is that just a whole list overall? And I guess what I'm getting at is, would a local government, a county, or even the state government under the impact-based state allocation be able to build, like, say, a civic center that has nothing to do with the ecosystem recovery under that? Right.
It's an and/or. My understanding is that the idea is that the overall purpose of the pot is to facilitate economic and ecological, but if you go back to, and I can't flip through the slides that quickly, but the list of allowable uses, you just have to satisfy one or more. Okay. Now, it may be that they'll give priority to projects that satisfy more than one, but you don't have to.
Centers of excellence, can they be NGOs that have science programs, or do they have to be governmental entities?
I believe they have to. I don't believe they don't have to be governmental, okay. But I believe, and correct me if I'm wrong, but I believe that they are meant to be kind of academic institutions. The idea is not to.
And then the restoration science program, the last one, does it have to be just about fisheries, or can it be science removed from actual fishery?
I'm so sorry, I didn't hear the first part of that.
I think you said that the data collection and monitoring of fisheries was the idea. Does it have to be, how close does it have to be to a fishery, an actual fishery? Or can it just be ecological studies of habitat that may lead to fisheries and things?
That's an excellent question. This is my gut reading of it, is that, if there's a nexus to the fisheries, certainly fisheries habitat has long been part of fisheries management in this country and of the statute, so that would be my reading of it, but I don't have an explicit answer to that.
Jennifer Hecker from the Conservancy. I had 2 questions. You had mentioned a couple of the pots had restrictions, like the Gulf Coast, it's only for natural resources, whereas the equal share state allocation could be for economic or natural resources. The impact-based state allocations, can that be for both, or is that restricted to one or the other?
That's for both. That's where it gets a little bit fuzzy. The allowable uses, literally the statute directs you back to the same list of allowable uses as for the equal shares pot. So that's ecological or economic. The little catch is that it still has to be consistent with the comprehensive plan that the council issues, and that comprehensive plan is ecological, or is for natural resource protection and restoration specifically. But the understanding and the general kind of read of it is that those 2 state pots of money can be used for ecologic or economic.
Okay, and then the second question I had, which had to do with the Centers for Excellence. You had said DEP and the Florida Fish and Wildlife Conservation Commission were two of the entities that would be administering this center, and that it was a grant program. Who decides, you had listed off those different things like offshore energy and sustainability and development and coastal fisheries and wildlife. You said it could be any one of those things. Who decides? Is that up to DEP and FWC then to decide what the grant program is going to focus on?
Yeah, so it includes DEP and the Fish and Wildlife Commission, Conservation Commission, but it's a consortium of public and private research institutions. So the idea is there will be this leadership group, not just DEP. But yes, they will decide who receives those grants, and they decide the prioritization of them. I don't know. I don't know of any explicit public participation opportunities. I think that's something that it will be interesting to see. One other thing that I realized I didn't focus on here because we do have limited time, but the council is actually required to establish advisory committees as necessary, and that they explicitly mention including a scientific advisory committee and a public policy advisory committee. That also leaves the door open to additional committees, and that may be an approach for that other parties may adopt. I'm not sure.
Jason Stolzfus with Charlotte County. You talked about the equal share state allocations and how in Florida that'll be split. 75% will go to the 8 disproportionately affected counties, and the remaining 25% will go to the other 15 Gulf Coast counties. For the impact-based state allocation that'll be managed by the consortium, there is no split as far as percentages that will go to the 8 disproportionately affected counties and the other 15 counties. However, one of the initial versions of the Senate bill included a split, and now those 8 counties are pushing for that split to be applied to the state pot when the Treasury Department issues the guidance that you talked about in a couple months. Do you have any idea when that was taken out of the Senate language and why? We're just looking for some kind of information that we can use as part of the 15 non-disproportionately affected counties when we address that issue at the state consortium level.
Right. The short answer is no. The longer answer is, so there was the original Senate bill. There was also a mini bill that was essentially an original rider that was passed, that was kind of floated. And then, so the Senate bill and the House bill went into conference, and that's when we got this hybrid version that came out. So my guess, which I'm never supposed to do, but my guess would be that it happened during conference committee. But I'm not sure, David or Bethany, if you guys know when that language came out. Yeah. Oh, sorry. He was just going to answer. Okay, great. And David will address that in much better form later. Yeah.
Judy Ott from Charlotte Harbor NEP. I was wondering what your perspective is about how the existing structure in Florida of the 3 National Estuary Programs along the Gulf Coast could help play a strong role in coordinating in all 5 of these pots, really. Do you have any, had you thought about?
I'm so sorry, I'm having a hard time hearing.
Do you have some thoughts about how the structure, the existing structure of the 3 National Estuary Programs along the Gulf Coast can help facilitate priorities under these 5 different funding sources?
Gotcha. I don't have any particular brilliance to share. I know Bethany is going to speak later this morning about how, kind of different options and how to come up with various priorities. I think that this is, with all of these processes, even though there aren't timelines specified, many of these, it is kind of guessed that many of these processes will move pretty quickly, especially if funding becomes available. I think most of us have realized when there is funding available, it goes quickly. So I think the idea is that it's great to draw upon as much existing knowledge as there is instead of kind of reinventing. But other than that, I don't have any specifics. Yeah. Okay.
I'm Mark Alderson, National Estuary Program Director from Sarasota. At any rate, there's been a lot of debate on this January 6th deadline with regard to the council submitting a comprehensive plan. We've heard on one hand that it's a strict deadline, and then we've heard that it's going to be 6 months after the council is formed. Have you heard anything on that in regard to what's actually in the act?
Right. There's certainly, in all of these processes, there's been some natural flexibility. For example, the task force, the Gulf Coast Ecosystem Restoration Task Force that will disband within 60 days of the council actually standing up. So their mandate was within a year to issue their recommendations, their findings from their research. Well, they issued the draft within a year, but then they took an extra couple of months to actually get public input and issue it. And essentially, if things are on track, I think my read is that there is some inherent flexibility here. On the other hand, the statute requires it within 6 months of enactment. So that is the statutory requirement. Whether or not that's allowed to be bent a little bit, I don't have the say in that. Yeah.
Rosalind Rowe with the Florida Park Service. I'm curious about the defendants. Why it's just the defendants? Why it's just BP now? What's happened to the others?
Mm-hmm. Well, so in NRDA, I think as Teresa was mentioning earlier, the responsible parties have the option of engaging, and BP is the only one who has. They're not the only defendant, and certainly in the Clean Water Act case, so the December 2010 complaint that the Department of Justice filed names not just BP. We actually have a list of the defendants in here, but it includes all the responsible parties, or all the potentially responsible parties. So BP is the only one who has chosen to come to the table for NRDA, but that doesn't necessarily mean that they're the only ones responsible. And the same is true for the Clean Water Act fines. MOEX is the only one who has stepped up and decided to already settle, but they're not the only ones that could. So it is all the responsible parties that are brought into it. Does that answer?
Jennifer Hecker, I can't recollect whether it's the council, but there was a lead federal agency that was supposed to be selected to head up. Mm-hmm. Is that the Restoration Council?
Yes, the council, a chair.
And people had thought that the best agency might be the U.S. Fish and Wildlife Service because of their focus on natural resources and habitat and whatnot. But now it's rumored that the Department of Commerce might be selected as the lead agency, which would put a lot of emphasis back on economic development. Mm-hmm. Do you have any comments or information, and can you explain to us, what is the significance of whatever federal agency is selected to lead up that effort?
Right. Well, so at the end of the day, they are just kind of one member of the agency. They will be on the agency, on the council, no matter what. I would say the one lesson that I have learned from the past 3 years is that every rumor I hear turns out wrong. So that's part of why, it's like we no longer surmise about much because we just don't have the ability to predict it. So I'm not sure. I've heard several different agencies mentioned as a probable chair. But in terms of their actual authority, it comes down to the voting. And whether, for example, with the state plans, then they will be the one that can approve the impact-based state plans, those funding plans. The one state member plus the chair can approve any of those plans. So that's one place where they do have specific authority. That representative will be on the council no matter what. It's just whether they get the additional duty. So it's not that they will have an additional person on the council or anything like that. It will just be who has that kind of higher level of authority. In terms of who it is, whether it's Department of Interior, Commerce, Agriculture, any of the appointees, I don't have any comments on that, other than to note that NOAA is within Commerce. So,
any additional questions? Oh, okay.
Yes, Jordan, I'm Bill Bile of Charlotte County Community Development, and I've got a real simple question that Mayor Denham may already know the answer to, but I was curious when you were talking about a coalition of counties, affected counties on the coast. Does that include places like Mix City of Sanibel? Will he have a representative there? Did I miss that somewhere?
Yeah, I will. The only thing I will say is that there is a variety of local entities that can be involved, but I will, if you don't mind, I'll save that question for David, since he's going to be going into some depth.
Okay, now my question is, you probably are aware of this, but the great majority of fish in the Gulf of Mexico grow up outside this building in supposedly the second largest and one of the most productive estuaries in the state. And most of those species out there spend part of their life, a very important part of their life, growing up here in the estuary. So we maintain this nursery, and they grow up and they go out there, and they go to war with the sharks and the fishermen and the oil companies, and a lot of them don't come home to maintain the cycle. I'm not sure how to ask this question, or maybe it's not the right place, but there's probably going to be a lot of competition for these pots of money. And I'm supposing that the scientists like at Mote Marine Lab and National Marine Fisheries and these people will try to figure out how much damage has been caused to the estuary by having all the fatalities out in the Gulf, so that we don't have this nice productive system working. I'm not quite sure where to go with this, but that to me is one of the biggest nexuses for Charlotte County getting into this is how, I mean, we don't have the oil spills out here in Punta Gorda Isles, but we don't have as many babies as we used to raise, and I don't know how you'd put a dollar figure on that.
Right. Just a few kind of thoughts generally on that. So one, to go back, so the restore money, I imagine that there will be a fair amount of competition for the individual funds. And I think that's part of why things like this, where you are kind of getting thoughts together kind of ahead of time and kind of pre-organized, are very important. But so that's the restore money. The other question is under NRDA. So if any of that damage, it's like if, okay, there's oil offshore, and in addition to competing with the sharks and everything else, that then they're competing with the oil or impacts of that's out at sea, then that is a natural resource damage that should be covered by NRDA, right? So there can be a nexus there. The challenge there is, how do you see that? How do you prove that? How do you quantify that? And that's why, as Teresa mentioned, that the NRDA can take so long. But also, one thing that we often talk about is what happens if you decide the dollar amount, whether via settlement or you go through the entire NRDA, and then there's stuff that you find out about later. It's deep sea or blue water restoration, kind of ocean restoration, is very challenging, and it's very hard to detect and Bethany, I should save all of this for you, but it's a very challenging subject. And so there's a question of, if you finish up the legal process, what is the role of a reopener clause? So if you find out about damages down the road, if you have a reopener clause in your NRDA agreement, or whatever comes out that accounts for later learned information, so that you can come back and revisit the question, so you don't close that door. They have existed in the past. They can be challenging as well.
Jordan, I guess maybe part of the question, or part of the thing I'm wondering is, will Charlotte County have to come to you with some sort of proof of this, or are some of the other agencies that, like DEP and National Marine Fisheries, and
Right.
Or can we sit back and just say, they're going to take care of this for us, we don't need to worry about it, they'll figure out how much damage has been done to us?
Right. The idea, so as Teresa mentioned, the challenge with NRDA is that because it's a legal process, there are specific kind of chains that the information has to go through. But I think that one of the things that we've consistently heard from the trustees is the flagging of issues. That they've asked for suggested projects. There's a portal online where you can submit your restoration project suggestion. And I think that type of information is very useful to the trustees and to submit. So I guess I'm just saying that I think if In general, I think it's always, what's the harm of making sure that you kind of, even if it's stuff that they already know, just making sure of kind of double checking. But theoretically, the NRDA trustees are gathering that information on their own, that they're actually going through and doing the systematic scientific analyses and gathering that information. But again, to emphasize, there's a lot here. It's being very challenging to figure out what the situation was before versus what it is now. So I typically always encourage people to, again, there's nothing but benefit to making sure that they've heard their concerns. But I also, just one point, so Teresa gave a bit of background on us, but we are a non-governmental organization. We don't have any role in this process whatsoever. We are completely useless in any sort of government sense. So just to let you know that we're here to try and make the process a little more transparent because that's part of our mission, but we don't have any say or utility.
Mick Denham from the City of Sanibel. You mentioned a number of times counties. So does this require a collection of various projects within a county, or could an individual entity have a particular claim? For example, if it was from, say, Fort Myers Beach within Lee County, or from Sanibel, if there was an entity there which said that they had some sort of issue caused by this catastrophe in the Gulf, could an individual entity, or has to be an amalgamation of all entities from a county? Yeah. Could there be individual projects?
That starts to bring up several questions. So I may actually take this opportunity to turn over to David, who will start to address that in his remarks, if that sounds good.